Welcome to Careers in the Virginia Judiciary. This is Kevin Lacey, and I will be your instructor for today. All right, moving on to our next slide now. And today we're going to be talking about two positions in the Virginia court system: deputy court clerks and magistrates. These aren't the only jobs within the court system. However, they're two of the most prevalent. I've listed some other positions that you could decide to apply for if you were interested in starting a career in Virginia's judicial system. And next, what you're looking at here is a website, the Virginia Courts.state.us. If you wanted to apply or check for openings for judicial positions, you would come on to this website and click on employment. This is just an example of a job opening for a deputy court clerk. If you're not able to see that, you may be able to zoom in and see that a little better. We'll get into the job requirements for that position in a few minutes. Okay, so if you wanted to be a deputy court clerk, you'd be earning around between $25,000 and $35,000 for a full-time position in Northern Virginia. The pay would be on the higher end of the scale because of the higher cost of living. It also includes a full benefits package, including health care, a leave system, holidays off, and a retirement system. Unfortunately, there's a relatively low salary structure compared to the private sector, and you're also subject to a rigorous code of ethical conduct, which there's nothing wrong with, but it may restrict you from doing certain things that you otherwise would be able to do, most notably political activities. To be a court clerk, a deputy court clerk, you need to have a high school degree. However, a college degree is increasingly preferred. You need to have organizational skills, the ability to multitask, and knowledge of court procedures is a plus. Also, this is a customer service job, so if you don't enjoy interacting with people on a daily basis, this may not be the right position for you. Alright, next I'm going to look at job duties of the deputy court clerk. These are just some of the many duties, but it'll give you a feel for what the court clerk does. They provide forms for a complainant to initiate a lawsuit. They issue subpoenas for criminal and civil cases. They index cases. They file the cases. They prepare the docket sheet. They accept prepayments before trial. They process continuance requests. They update case information after a court hearing, and they advise the public on the status of their cases. These may seem like relatively simple tasks, but they're not. Each requires a lot of procedures, and a lot of them are very specific to the division that you'd be operating in. On the plus side, there are opportunities for advancement. If you became a deputy court clerk, you could move up to become a supervising deputy court clerk and a chief clerk. There also might be higher management positions within OES, which I'll explain that in a minute what OES is. For magistrate, the salary structure is a little higher. You're going to be getting between $40,000 and $50,000. You get the full benefits package that we talked about before. For negatives, though, you have to work holidays, weekends, and nights, and there's also that restrictive code of ethical conduct. Okay, to be a magistrate, a college degree is required. A law degree and membership in the Virginia Bar are now preferred credentials. Experience in the criminal justice system is also preferred. So as a practical matter, you're really looking at law graduates and barred attorneys only from here on out. Okay. Magistrates A magistrate's job duties are a little more judicial, a little less administrative. However, there are definitely administrative aspects to all of this because they do all of their own paperwork. They authorize arrests and search warrants, they set bail in criminal cases, they issue mental health detention orders, protective orders, and like the clerks, they also accept prepayments before trial. Okay. There are also a lot of opportunities in the magistrate system. You could become a chief magistrate, a regional supervisor, or a magistrate advisor. Alright, next I'm just going to refer you to some of my recommended resources. The Office of the Executive Secretary of the Supreme Court, which is OES, who all the deputy clerks and the magistrates operate under, has published two manuals, the Virginia Magistrates Manual and the General District Court Manual. Both of these are available at that website that I talked about, courts.state.va.us. If I wasn't clear about that before, that is the website that you would need to go to apply for one of these jobs. Okay, so now we're going to do two walkthroughs, one for the court clerk and one for the magistrate, and this will just give you a sense of how these positions operate. So first of all, what is the General District Court? Because that's really the position that we're talking about here, a clerk for that court. It's the first court for a lot of people, but not always the last. It has jurisdiction in civil cases where under 25,000 is in dispute. It holds all trials for misdemeanor offenses. It conducts felony preliminary hearings. And it's usually organized into three divisions. You have a civil division, a traffic division, and a criminal division. On the other hand, we have circuit courts. They handle cases in which the amount in dispute is over 25,000 for civil. They conduct all felony trials, and they handle appeals for civil and criminal cases from the General District Court. Another type of court is a JDR court, a juvenile and domestic relations, and that's a specialized type of General District Court that handles domestic disputes and cases involving juveniles. Once again, if there's an appeal from JDR, Circuit Court would handle that appeal. Okay, so going back to our walkthrough, part one, case initiation. This is the situation where someone wants to file a lawsuit at the clerk's office. So the clerk would provide the forms to the complainant, that's the person that wants to file the lawsuit. The clerk can give limited assistance as far as instructing people on the different aspects of the form that need to be filled out, but they can't provide legal advice. After the case is filed, the defendant in the suit has to be served, and that can either be by private process server by the Sheriff's Department, and we'll get into that in a minute. But first, let me show you, this is a form for a warrant in debt in the Small Claims Division. It's an example of one of the forms that the clerk would give to the complainant to fill out, and then once that form is filled out and filed, that becomes the paper record for the case. And there's going to be two records that the clerks are going to have to handle. That's the paper record and the electronic record. But what you just saw there is the paper record. Okay, part two, the clerk's going to collect processing fees from the plaintiff. There are situations where no fee is charged pursuant to the Code of Virginia. You can look at that there, and that explains the situations for that. An example of how precise the procedures are that have to be followed if you're in the clerk's office. Part three involves case indexing, where the clerk is going to assign a sequential case number onto that form that was filed. In this case, it will be placed on the DC 412 warrant in debt, which is what you just saw. Because this is a civil case in our example, you have GV plus the year plus the sequential number plus a suffix. After that, the information that you received on paper has to be entered into an electronic case management system. And here's just an example of what that looks like. Okay, part 4. The clerk needs to determine jurisdiction and, if appropriate, issue the process by signing the warrant portion of the DC 412, which is the form you just saw, and then sending it to the sheriff for service. Virginia Code allows for the return date to be within 60 days of the date of service on the defendant. All right. Next we have Part 5, keeping the case file updated. I have to remember that before trial, parties will be making various preliminary motions before the judge. The parties also have an opportunity to settle the case before trial. The clerk's duties are going to involve processing motions for judgment served by the sheriff, filing all civil warrants and motions for judgment in the appropriate file, and preparing a docket, which is just simply the list of cases that are going to be heard each day. Clerks are also going to be involved in issuing subpoenas and documents, and I'll get more detailed on that with the next slide. So basically, the clerks need to keep the cases updated, and they need to do it in the electronic case management system, which you saw a glimpse of briefly before, and on the paper copy as well. In the case where the clerk is asked to issue a subpoena by either the complaining party or an attorney for one of the parties, or also could be a defendant, the procedures as laid out in the manual, the district court manual, or to verify that the request is returned with the proper court, obtain phone numbers, and note the date and time of receipt of requests, and then prepare and issue the subpoena. And magistrates can issue subpoenas as well. It's another common practice. All right, part 6. This is when all the preliminary matters are resolved, and we have a trial before the General District Court. And when cases are going to be going to trial, the clerks are going to bring all of the case files and the docket sheet for the day's case to court, and then would record the disposition on the docket and the warrant, which is the form that you saw, the paper copy, and in the case management system, the electronic system. So we want to record the disposition after the judge makes his ruling. In post-trial duties, we're looking at, as I noted before, recording the disposition in CMS, the case management system, processing appeals. Pretty much in civil cases, any judgment over $50 can be appealed to the circuit court. And then process execution of court orders per plaintiff's requests. Remember, in a civil judgment, it's really the burden is on the plaintiff to make sure that the judge's order is enforced so they can collect their money, so they can apply to garnish the defendant's wages, or place a levy on defendant's property, which can then be possessed by the plaintiff and sold again. Okay, now we'll just do a walkthrough of a magistrate. We'll cover 2 of the primary functions, which are for them to determine probable cause and then to set bail for criminal defendants. Magistrates largely operate in the criminal realm, which is what probable cause and bail are all about. Probable cause is just there's a 2-part test. The complainant, the person that wants to bring a criminal charge, must actually allege a crime, and the alleged facts have to have a reliable basis. It can't be arbitrary and unreliable. To initiate a case or to bring charges or attempt to bring charges, a citizen can do that if the citizen wants to file a misdemeanor charge against another citizen. Law enforcement can bring misdemeanor and felony charges. In addition, law enforcement is required to bring the defendant before a magistrate for probable cause in case of a warrantless arrest. That's when an officer arrests you without having first obtained a warrant. In this case here, what we're looking at is a criminal complaint form. Anyone that wants to bring a criminal charge, at least a citizen, has to fill out this form. For law enforcement, the magistrate can decide just to take verbal testimony, but the magistrate can also require that that testimony be reduced to writing, and this would be the form that would be done. And the form just sets forth the allegations, and like I said, the allegations have to allege a crime, and there has to be a reliable basis for the allegations. What you're seeing next is an example of a felony warrant. If a magistrate were to find probable cause, they would issue a piece of paper like this, and it would describe the individual that's being accused of the crime. It would specify what the alleged crime was and what date it occurred. It would also specify which court the case will be heard in. Alright, that is our felony warrant. Now we'll be moving on in a few seconds. Alright, so what does a warrant do exactly? Well, if someone is not in custody by the police, it authorizes the police to go out and arrest them and bring them before the magistrate for a bail hearing. If someone is already in custody without the warrant already existing, the warrant effectively legitimizes the arrest that has already taken place. Now, in the event of a warrantless arrest, if a magistrate fails to find probable cause, the police have to release the individual from custody immediately. This is known as a de-arrest procedure. Alright, next we'll just cover briefly what bail hearings are, and then we'll all be done with our walkthrough. Okay, so bail hearings. After a warrant is obtained, the magistrate decides whether the accused can be released from custody pending trial. This is called being on bail. So bail only happens if the magistrate finds probable cause, either before or after the arrest. But once a probable cause finding has been made, then the magistrate proceeds to determine if the accused, or which is another way of saying the criminal defendant, is eligible for bail. Alright, and we'll just get into that briefly, and then we'll be wrapping things up. Alright, there are 4 types of bail. Recognizance is when the accused is released on his or her signature. An unsecured bond requires the accused to forfeit whatever amount of money the bond is for in the event that the accused fails to appear in court. However, the accused does not need to demonstrate solvency before release. So it's effectively a recognizance with the threat of a financial penalty. In a secure bond, the accused has to demonstrate solvency before he or she is released from custody. This is where we get the bail bond companies, the dog, the bounty hunter stuff, all of that fun and interesting activities. And then the magistrate can also hold somebody without bail, and then they're held until the next day that the court is in session, and a judge reviews that decision to hold without bail. Generally, Virginia law presumes that someone accused of a crime is eligible for bail unless the magistrate believes the accused will not appear in court or believes the accused would be an unreasonable danger to the public. Alright, that's going to wrap things up, and I hope that this course has given you some ideas for planning a future career in the judiciary. I'm Kevin Lacey, and I hope you enjoyed this presentation.